Hello dear students, I Anuradha Goswami, Senior Assistant Professor, Department of Commerce from the Bhopal School of Social Sciences welcome you all for this video presentation titled Contract of Indemnity. The content of this video presentation are meaning, definition, object and parties of indemnity contract. I will also explain the essentials of valid contract of indemnity followed by rights of indemnity holder and indemnifier. I would like to begin my session by explaining what we mean by the term indemnity and contract of indemnity. The word indemnity has been derived from the Latin word indemnis, which means unharmed or undamaged. According to the dictionary meaning, indemnity is protection against possible damage or loss. In common parlance, the word indemnity implies reimbursement against financial loss or to protect someone from incurring a loss. So, indemnity in simple word means protection against future loss. A contract of indemnity means an agreement made between two parties in which one party agree to pay for potential losses or damage suffered by the other party. Contract of indemnity is made in order to protect the promisee against anticipated losses. Now, let us see the definitions of contract of indemnity, which is being defined under section 124 of the Indian Contract Act 1872. A contract by which one party promised to save the other from loss caused to him by the conduct of the promiser himself or by the conduct of any other person is called contract of indemnity. Contract of indemnity is a special type of contract. Section 124 and 125 of the Contract Act 1872 are applicable to these type of contracts. In a contract of indemnity, there is only one contract, that is between the indemnifier and the indemnified. Although the above definition restrict the scope of contract of indemnity as it cover only the losses caused by the conduct of promiser himself or by the conduct of any other person. If a strict view is taken of the definition, it will exclude the losses caused by accidents. In that case, insurance contract should not fall within the purview of contract of indemnity. But the fact is that all contract of insurance except life insurance are also contract of indemnity. The basic object of indemnity contract is to protect the indemnity holder from loss or damage upon the happening of contingency by the indemnifier. The objective of entering into a contract of indemnity is to protect the indemnity holder against future losses. While discussing the object of indemnity contract, we came to know about two terms which are indemnity holder and indemnifier. Actually, every contract of indemnity has at least two parties. The first party is the promiser or indemnifier. He is the person who promised to bear the loss. The second party is promisee or the indemnified, and he is also known as indemnity holder. He is the person whose loss is covered or who is compensated. For easy understanding of these terms, I'll give you an example. Suppose Arshpreet enters into a contract with Alfred to protect him against the consequences of certain action which Ansh may take against Alfred. As per our above stated example, Arshpreet is the indemnifier or promiser as she promises to bear the loss of Alfred. Alfred here is the promisee or the indemnified or indemnity holder as his loss is covered by Arshpreet. Now, let us take a look at the essentials of valid contract of indemnity. The first essential is protection against loss. As we know, the contract of indemnity is entered into for the purpose of protecting the indemnity holder from the loss, although the indemnifier will compensate under following conditions only. A. There must be a loss. B. The loss must have caused either by the indemnifier or by any other person. C. The loss must fall within the scope of indemnity contract. Hence, it is clear that indemnity contract is a contingent contract and it is enforceable only when the loss is actually suffered by the indemnity holder. The fact to be kept in our mind is the liability of indemnifier is primary and independent. The second essential of valid contract of indemnity is at least two parties. It simply means under every contract of indemnity, there must be two individuals. The first person who gives the promise for compensating the contingent loss of other is known as indemnifier, and the person who received this promise of safety against the future loss is known as indemnity holder. The third element of valid contract of indemnity is that it could be either express or implied. The contract of indemnity may be express, that is made by words spoken or written, or implied, that is inferred from the conduct of the parties or circumstances of the particular case. The fourth essential of a valid contract of indemnity is that it must possess all the essentials of valid contract as mentioned in section 1 to section 75 of the Indian Contract Act 1872. Now, I will explain the rights of indemnifier and indemnity holder. First, I will talk about the rights of indemnity holder. As per section 125 of the Indian Contract Act 1872, the following rights are available to the indemnity holder provided he has acted within the scope of his authority. The first right is to recover damages paid in a suit. Under section 125 of the Indian Contract Act 1872, an indemnity holder has the right to recover from the indemnifier all damages which he may be compelled to pay in any suit in respect of any matter in which the contract of indemnity applies. In simple words, the indemnifier will have to pay damages which the indemnity holder will claim in a suit. The second right is to recover cost incurred in defending a suit. Under section 125 subsection 2, an indemnity holder has the right to recover from the indemnifier all cost which he may have compelled to pay in any such suit if in bringing or defending it he did not contravene the orders of the promisor and acted as it would have been prudent for him to act in the absence of any contract of indemnity, or if the promisor authorized him to bring or defend the suit. In simple words, the indemnity holder can even compel the indemnifier to pay the cost he incurs in litigating the suit. The third right is to recover sums paid under compromise. Under section 125 subsection 3, an indemnity holder also has a right to recover from the indemnifier all sums which he may have paid under the terms of any compromise of any such suit, if the compromise was not contrary to the order of the promisor and was one which it would have been prudent for the promisee to make in the absence of any contract of indemnity, or if the promisor authorized him to compromise the suit. In simple words, if parties agree to legally compromise the suit, the indemnifier has to pay the compromise amount. Now, let us see the rights of indemnifier. The fact worth mentioning here is that the Indian Contract Act 1872 is silent about the rights of indemnifier. The right of indemnifier have not been mentioned expressly anywhere in this act, but in Jaswant Singh versus section of state, it was mentioned that the right of the indemnifier are similar to the rights of a surety under section 141. Hence, the indemnifier has following rights. The first right enjoyed by indemnifier is right of subrogation. The principle of subrogation, that is substitution, is based on principle of equity. It means once the indemnifier pays for the loss or damage caused, he will step into the shoe of indemnified. Thus, he will have all the rights with which the original indemnity holder protected himself against loss or damage. The second right enjoyed by indemnifier is to refuse indemnity. In case the loss suffered by indemnity holder is beyond the scope of the contract of indemnity, then indemnifier can refuse to pay any compensation to the indemnity holder. Now, I will conclude this presentation by reconfirming the fact that Contract of indemnity means doing good to the person who has suffered loss or putting the person back into the same position as if no loss has occurred. The person promising or assuring the payment of compensation is called indemnifier, and the person in whose favor such promise or compensation is made is called indemnity holder. The definition of contract of indemnity is restricted only to those cases which arises due to the conduct of some human agency and not otherwise. The indemnity holder can recover all the damages, cost and amount paid in case of compromise from the indemnifier. The right of indemnifier are similar to that of a surety. Thank you, dear students. I hope this video presentation will help you in understanding all the basic concepts related to contract of indemnity.